You're listening to Bloomberg Law with June Grasso from Bloomberg Radio.
Opioid overdoses killed nearly 500,000 Americans over 2 decades, and the epidemic is getting worse instead of better. DEA Administrator Ann Milgram says an American is dying every 5 minutes from an overdose, and 75% of those deaths are from opioids.
It's, Americans of all ages, cuts across every single demographic, rural, urban, suburban, and that people are dying at record rates.
San Francisco says opioid manufacturers Allergan and Teva, distributor Anda, and pharmacy giant Walgreens flooded the city's streets with prescription drugs. And it's suing over the toll opioids have taken on the city, where 1/4 of emergency room visits are the result of opioid-related issues. Joining me is healthcare attorney Harry Nelson of Nelson Hardiman. Harry, San Francisco is using a public nuisance theory. What does it have to prove to make its case?
So, to prove a public nuisance, San Francisco has to prove that the 3 drug companies at issue, along with Walgreens Pharmacy, basically engaged in behavior that so harmed so many people in San Francisco and that they need to be essentially forced to pay for that harm. And the harm here that we're talking about, of course, is prescription opioids. And the claim is that these companies are responsible for having flooded San Francisco with prescription opioids and then failed to prevent them from being routed into the illegal market for misuse.
San Francisco claims they aggressively marketed opioids to doctors as a risk-free panacea for all forms of pain. What's the line between aggressively marketing and just marketing?
It's an interesting question. I think, it's much easier when we talk about this question of where the line is on marketing to look at behavior from, for example, Purdue Pharma, where it was very clear that they were aware that the problem of overdoses and the addictiveness of the drug was causing problems, and they just kept marketing more aggressively and sort of building that issue into their marketing. It's a lot more fuzzy when you come to companies like Walgreens or Allergan, Teva Pharmaceutical, where they were offering these drugs in the market. It's not clear what they did that was so unusual in that marketing. And frankly, I think that the city's going to have a very hard time showing that there was anything particularly distinctive about the way that these drugs were promoted that somehow ignored the risk associated with them.
The defendants claim that they were sort of bit players in the opioid crisis, and they say the blame should be directed at Purdue, which has declared bankruptcy.
I think it's a compelling argument. The reality is that there were a lot of companies that manufactured and distributed, and in the case of the pharmacies, dispensed these drugs, but they are not all equal, right? Purdue Pharma made billions of dollars and orchestrated an aggressive campaign to manipulate how doctors and patients perceived the risk. There's not the same kind of evidence with regard to Allergan and Teva. These are companies that clearly had a business line devoted to pain medication, but there's no signs that I've seen to this point to suggest that they were somehow scheming to hide the risks associated with these medicines or doing something to promote them more aggressively than all the other medications that they sell. I personally think that the city has an uphill battle in this case.
Before trial, defendants J&J and 3 large distributors reached a $26 billion nationwide settlement of opioid claims. As I mentioned, Purdue went bankrupt. 5 days before trial, Endo Pharmaceuticals reached a deal with the city. Let's say the jury does find these drug companies in this trial liable. Do they consider the settlements in deciding damages?
If they reach a decision that there is liability, that the city proved its case of a public nuisance, the jury will then be asked to apportion responsibility and to allocate some responsibility to different companies. So there's going to be a moment where a jury is asked to decide how much Allergan, for example, is responsible, or how much Walgreens is responsible of the total amount of liability here. And that's a very, it's hard to see how a jury is going to be in a good position, assuming that they get that far, to make a really nuanced decision when you have a lot of different companies, promoting a drug for which there was enormous demand, clearly, for pain, but which was risky. That's a process the jury will be forced to go through, but I can't say that I am optimistic that it will be a an easy one or necessarily precise one for deciding how much each party should be responsible to pay.
Do you have any insight into why the other, why J&J, Endo, et cetera, why they decided to settle?
Some of these companies have previous cases where there has been more negative evidence. So I think in the case of Endo, for example, there was some evidence, not nearly to the extent that we had against Purdue Pharma, but that they were a company that was aware of the risk and was marketing, for example, offering inducements to doctors to promote the drug. So Endo was one of those companies that had more risk because there was some bad behavior. And I think that a lot of the companies that chose to settle were companies that had something that they were afraid the prosecutors and the city attorneys here would point to actually make them look like they had behaved badly. And my feeling is just the opposite, that in this case, the companies that are still standing don't see that evidence and are challenging the city to make a case that they actually did anything wrong here.
Some of the claims against Walgreens are that the pharmacy was under guidelines to take 15 minutes to fill prescriptions and they didn't check enough. That seems pretty thin.
Yeah, my perspective on this is that over the last 2 decades, we've seen the standards that are expected for pharmacies, for example, change radically. And this whole set of expectations of how much compliance, how much verification a pharmacist and a pharmacy is expected to do to verify that something is legitimate have been completely overhauled. But we're not talking about Walgreens actually affirmatively doing anything bad. We're saying that they failed to do certain checks that we wish they would have done. I definitely think that if you talk to anybody who is learning to be a pharmacist today, they're learning a very different set of responsibilities than the people who went through pharmacy programs 20 years ago. But I do think that I think it's a tough argument because there was a way of doing business. Pharmacies were entitled to just see that if it really was a prescription from a doctor, to assume that it was legitimate. And then all of a sudden, in cases like this, the argument is being made that no, the pharmacist had to do more. And it's not clear how much more pharmacists could do beyond just seeing that a doctor prescribed this to a patient. It's not clear that we want pharmacists to be second-guessing doctors. So I actually think there's a very tough argument the city is going to have to try to prove here.
This public nuisance legal strategy against drug makers for causing or fueling the opioid crisis hasn't had a very good track record, has it? A California judge ruled in favor of the defendants, 5 pharmaceuticals, including Teva, 5 months ago, and the Oklahoma Supreme Court overturned a ruling against Johnson & Johnson. Has this public nuisance argument been successful anywhere?
Yeah, it has had more failures than successes. It's definitely, public nuisance comes out of an environmental context where it was much easier to say that a certain company polluted the environment in a certain area, and it was a very direct link from the source of the harm to the actual harm, the pollution in those cases. In this context, where we see a legitimate medication manufactured, distributed, prescribed by doctors, dispensed, and then traveling through the system in ways that cause harm, people getting addicted, people selling it onto the street, it's a lot more complicated with a lot more different players, and it's not that clear link that we see in those environmental cases. So I think that the public nuisance, I understand why it's appealing to government and to attorneys who are looking to make a case to try to get the costs that were imposed here, which were significant on healthcare, on law enforcement across communities, to be shared. But it's not an easy theory, and I'm not bullish on the future of public nuisance litigation in this area.
This is the 4th Bellwether case, I believe, chosen for trial from about 3,000 in the federal opioid litigation. Explain why it's called a Bellwether case, what that means.
We had a logjam, of just thousands and thousands of cases that had to be tried. So when we say Bellwether, the judge in this case was basically selecting a handful of representative cases to look at harms in different contexts. So this, I believe, is the first urban-focused case of how did opioid harm, how did it progress, what did it look like in a city as opposed to some of the rural cases, for example, in Ohio that were marked as bellwethers. So the idea is that hopefully the parties see how the arguments play out in these cases, how juries respond to them, and they use that as a kind of test so that we don't have to go through the same exercise over and over again, and that the parties on both sides will have a better sense of what their odds of success are, what their liability risks are, and settle cases based on the indicators that come out from this case.
Let's talk just a little bit about Purdue. A $6 billion deal was approved in bankruptcy court last year, but an appeals court threw it out in a surprising decision, and now it's being argued over in a New York court?
Yes, so this is super interesting. The reason the settlement was thrown out on appeal was the question of whether a bankruptcy judge had the power to give the members of the family, the Sackler family, which owned Purdue Pharma, protection, right? The Sackler family is a very wealthy billionaire family that did not file for bankruptcy. The company that they founded did, but their insistence was that they were only going to settle and pay these billions of dollars out of Purdue if they also were given this legal shield. And so the court overturned that, and so now the parties are back in court arguing about it, and we're still seeing the family completely dug in and protecting themselves, right? The family, by the way, reports have come out that the family took over $11 billion out of the company in the years that they were aware of this crisis. And so it's still up in the air whether we're going to get a settlement here. I assume we will eventually, but it's a fascinating question of how far courts can go to protect the individual families from the harm resulting from the company that they owned and managed.
And the Sackler family has come to represent sort of like the evil kingpins of the opioid crisis. So there's not much sympathy for them at all.
You know, the truth is that, most of the family was far away from this business. There were a handful of family members, Dr. Richard Sackler, who were at the heart of this. In some ways, it's a tricky thing. The family clearly, anytime you walk away with over $10 billion from a business that killed thousands of people and imposed billions of dollars of harm, you're going to have a tough time getting sympathy. But I do feel for the family members who weren't involved that their name, which was used to grace, museums and all kinds of, amazing medical schools and institutions all over the world for their philanthropy, has now become the sort of keyword for abusive behavior in the pharmaceutical world. So it's a lot of damage to the Sackler name that's going to last far longer than these cases.
And finally, I wanted to get your take on the Commissioner of the Food and Drug Administration told the Senate that he wants to toughen standards for drug makers who want to sell new opioids. Congress would have to give the FDA that power. Do you think that's a good idea?
Look, I think it's a good idea, although I think there's a real conundrum here. The reality is that something like 1 in 5 American adults, 50 million people, complain that they live in severe or serious chronic pain. So we have an enormous need for these drugs. We've learned how dangerous they can be, how addictive they are, but we've also seen that when you deny people access to them, it leads to terrible things, including increased risks of suicide. And so we do need more controls, and I think it's a good thing for there to be more effort. But at the same time, we've learned, for example, that when the FDA requires the drug companies, for example, to put out additional educational materials to doctors so that doctors understand the risk, and the net outcome of that is that doctors actually prescribe more of the medication. So I think that we sort of have these opposing tensions where there's an enormous need for these medications. Doctors are nervous in the current environment about what they can and can't do. And I think more clarity from government, more requirements that if those translate to making it safer for doctors to prescribe to patients, I think those will be a good thing.
Thanks, Harry. That's Harry Nelson of Nelson Hardiman. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcasts. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. I'm June Grasso, and you're listening to Bloomberg.